Let's talk about the Americans with Disabilities Act and employment. So the big question, who exactly is covered under ADA Title I law? Title I employment provisions apply to private employers, state and local governments, employment agencies, and labor unions. Employers with 25 or more employees were covered as of July 26, 1992. Employers with 15 or more employees were covered 2 years later, beginning July 26, 1994. Title I of the Americans with Disabilities Act of 1990 prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and any other terms or privileges of employment. The ADA covers employers with 15 or more employees, including state and local governments. It also applies to employment agencies and to labor organizations. For entities covered under Title I, what exactly does that mean for the business? Job application procedures, hiring and firing, advancement, compensation, training, and any other terms and conditions of employment, including recruitment, advertising, tenure, layoff, leave, fringe benefits, and all other employment-related activities. And speaking on that point, who exactly is protected under the ADA? Discrimination in employment is prohibited against qualified individuals with disabilities. This includes applicants for employment and their employees. An individual is considered to have a disability if he or she has a physical or mental impairment that substantially limits one or more major life activities, and has a record of such employment, or is regarded as having such an impairment. Persons discriminated against because they have a known association or relationship with an individual are also protected. Under the ADA, who exactly qualifies as a person with a disability? A qualified individual with a disability is a person who meets legitimate skill, experience, education, or other requirements of an employment position that he or she holds or seeks, and one who can perform the essential functions of the position with or without the reasonable accommodations. Do I have to give job preferences to people with disabilities? An employer is free to select the most qualified applicant available and to make all decisions based on reasons unrelated to a disability. Now, we hear a lot about reasonable accommodations, but what exactly are reasonable accommodations? A reasonable accommodation is any modification or adjustment to a job or the work environment that will enable a qualified applicant or employee with a disability to participate in the application process or to perform any essential job functions. Reasonable accommodations also include adjustments to ensure that a qualified individual with a disability has the same rights and privileges in employment equal to those employees without disabilities. I get that, but what are some examples of those accommodations? Some examples of those would be restructuring a job, modifying work schedules, acquiring or modifying equipment, providing qualified readers or interpreters, or appropriately modifying examinations, training, or any other programs that that person may have access to. An employer is only required to accommodate a known disability of a qualified applicant or employee. The requirement generally will be triggered by a request from an individual with a disability who frequently will be able to suggest an appropriate accommodation. Accommodations must be made on an individual basis because the very nature and extent of a disabling condition and the requirements of a job will vary in each case. If the individual does not request an accommodation, however, the employer is not obligated to provide one. The employer's obligation under Title I is to provide access to an individual applicant to participate in the job application process, and for an individual employee with a disability to perform the essential job functions of his or her job, including access to a building, to the work site, or any other needed equipment, and to all facilities used by employees. Under Title I, an employer is not required to make existing facilities accessible until a particular applicant or employee with a particular disability needs an accommodation, and then the modification should meet that individual's work needs. An employer can also hold employees with disabilities to the same standards of production and performance as any other similarly situated employees without disabilities for performing the essential job functions with or without reasonable accommodations. An employer can also hold employees with disabilities to the same standards of production and performance as other employees regarding marginal functions, unless the disability affects the person's ability to perform those marginal functions. If the ability to perform those marginal functions is affected by the disability, the employer must provide some type of reasonable accommodation, but may not exclude an individual with a disability. Now here's a big one. Are people who are currently using illegal drugs covered under the ADA? No. Individuals who are currently engaging in the illegal use of drugs are specifically excluded from the definition of a qualified individual with a disability protected by the ADA when the employer takes action based on the basis of their drug use. And to follow up on that one, are alcoholics covered under the ADA? Yes. A person who currently uses alcohol is not automatically denied protection. An alcoholic is a person with a disability and is protected by the ADA if he or she is qualified to perform the essential functions of that job. An employer may be required to provide an accommodation to an alcoholic. However, an employer can discipline, discharge, or deny employment to an alcoholic whose use of alcohol adversely affects the job performance or their conduct. An employer may also prohibit the use of alcohol in the workplace and can require that employees not be under the influence of alcohol. Does the ADA override federal health and safety laws? The ADA does not override health and safety requirements established under other federal laws, even if a standard adversely affects the employment of an individual with a disability. If a standard is required by another federal law, an employer must comply with it and does not have to show that the standard is job-related and consistent with business necessity. ADA employment laws covered under Title I also extend to discrimination based upon association or relationship with somebody. Let's explore that. The ADA prohibits discrimination based on relationship or association in order to protect individuals from actions based on unfounded assumptions that their relationship to a person with a disability would affect their job performance, and from actions caused by bias or misinformation concerning certain disabilities. For example, this provision would protect a person whose spouse has a disability from being denied employment because an employer's unfounded assumption that the applicant would use excessive leave to take care of the spouse. It also would protect an individual who does volunteer work for people with HIV and AIDS from disciplinary employment action motivated by that relationship or association. And what type of record keeping does an employer need to maintain concerning disability law? An employer must maintain records such as application forms submitted by applicants and other records related to hiring, requests, reasonable accommodations, promotion, demotion, transfer, layoff or termination, rates of pay, or other terms of compensation. If a charge of discrimination is filed or an action is brought by EEOC or the Equal Employment Opportunity Commission, an employer must save all personal records related to the charge until the final disposition of the charge. An employer can also establish attendance and leave policies that are uniformly applied to all employees regardless of disability, but may not refuse leave needed by an employee with a disability if other employees do get such leave. An employer may also be required to make adjustments in leave policy as a reasonable accommodation. The ADA requires that employers post notice describing the provisions of the ADA. Oftentimes we'll find these in break rooms. It must be made accessible, as needed, to individuals with disabilities. A poster is available from the EEOC summarizing the requirements of the ADA and other federal legal requirements for non-discrimination, for which EEOC has enforcement responsibility. EEOC also provides guidance on making the information available in accessible formats for people with disabilities. So, concerning Title I, who exactly enforces the ADA? An individual or a specific class of individuals or their representative alleging discrimination may file to have ADA enforced. Employment provisions of the ADA are enforced under the same procedures now applicable to race, color, sex, national origin, and religious discrimination under Title VII of the Civil Rights Act of 1964 as amended and the Civil Rights Act of 1991. Complaints regarding actions that occurred on or after July 26, 1992 may be filed with the EEOC or designated state human rights agencies.
Hi, is this the EEOC? I was calling to file a complaint against my employer. Okay, thank you.
And concerning that, what types of remedies are available? There are many available remedies. Some of those include hiring, reinstatement, promotion, back pay, front pay, restored benefits, reasonable accommodation, attorney's fees, expert witness fees, and all court costs. Compensatory and punitive damages also may be available in cases of intentional discrimination, where an employer fails to make a good faith effort to provide a reasonable accommodation.